Now, let's have you introduce yourself.
My name is Scott Heisey, and I'm with Stewart Title of California. Presently, I'm the Title Operations Manager for Northern California.
Now, here in Northern California, we have escrow office, an escrow officer, and an escrow in a major part of town. And then downtown somewhere, we have a title officer. And behind those two, there's an underwriter. Okay. Is that somebody like yourself that's crossing the T's, dotting the I's?
It's mostly the elevation of risk and liability that would run from escrow to a title officer. And then if it was outside of their expertise or liability limit, it would then run up through an underwriter, and of which I've been an underwriter several times before in my career. I do have that experience.
So today we're speaking about, let's say, people have a Winnebago, 2 cars, a bass fishing boat, a condo in Hawaii, and their single family home that's been in the family for decades. However, they don't have a will, they don't have a trust. So all of that wealth, so to speak, goes into a probate court with a probate judge, correct?
That would be correct. Oh, I'll expand on that since you mentioned, let's say, a condo in Hawaii. The unfortunate part is that may split up and they'd have to be doing multiple probates, one in Hawaii, one in California, assuming that property in California or in the Bay Area. So then you're looking at potential ancillary probate cases, which then obviously is very expensive and convolutes the probate process.
Right. When I hear people that say, oh, we didn't get a trust, we didn't want to spend the money, or our parents didn't want to, or our grandparents didn't want to spend the money, which is of dollars to have a trust created, versus a probate is typically perhaps the first $100,000 in value. It might be $8,000 for starters.
Correct.
And that's per state, right?
That is true. And that's what's funny is the trust, even though it may be expensive, it's money well spent up front.
Just to review for the lay people and those who don't want to spend money on a estate planning attorney or elder law attorney. So we have the items in the safe deposit box, everything at their homes, in their garage, the boat down there at the harbor, and the home that they live in. That needs to be protected so that when they are no longer with us, they pass away, those items have been designated to certain individuals or to be sold, and then their heirs can split the proceeds.
Absolutely. Think of it this way, and we talked about this earlier, is that a trust is a probate done while you're still alive from start to finish, based on your assets and your heirs that exist at that time.
You have also mentioned that people often say they have a will. You have spoken about a will, saying that's just their wishes. Which relative will get what part of the estate. Is that right?
That is correct. And to expand on that, a will has to be validated. It can't just be actionable based on the fact that you wrote it down and even had it notarized. So it has to run through the probate courts to be ratified by the judge, essentially, and give people a chance to air their grievances, unfortunately, and fight over trivial things, many times a cookie jar or a painting, let alone real estate.
That's right. We hear about those stories all the time where family members will fight over a Tweety Bird doll that was in mom's kitchen.
Yep.
Hire the attorneys. So that's an actual case, by the way, in Georgia, I think. So now, so we have the will, but if it's just standalone will, these are our wishes when we pass away, that's still going to go to probate and people are still going to fight over that. It's very expensive with the court system. Conversely, if they invested a few $1,000s in a trust, you have spoken about it's really the paperwork that wraps around a will.
Absolutely. It wraps around the will. It basically takes those wishes and solidifies them into a trust. So then this becomes actionable at that point. So your wishes are now cemented into the trust. And then if you become incapacitated or pass away, it should run through the normal course of events, which then would be with a successor trustee or somebody to facilitate your wishes as they would have been stated in a will to begin with.
Part of your program is who can act on behalf of a trust?
That's a great question. And it's really funny is that we talk about a trust as being, let's go back to what you said about safe deposit box. It's a depository for your assets, right? It's a vault to hold all those things that you own and hold dear that you want to pass down to your heirs and beneficiaries. So who do you appoint? If you're no longer able to act, then you appoint a successor trustee. And the root of that is trust. Who do you trust to fulfill your wishes upon your demise or incapacity? And you have to choose carefully, choose pragmatically. And so that would be the successor trustee. Unfortunately, in many cases, in certain demographics, let's put it that way, they automatically appoint the eldest child to act automatically, which many times is the wrong person to put in charge. And we run into that on the real estate side all the time.
That, you made a good point there about successor trustee. Oftentimes, I've worked for co-trustees, the eldest son and second eldest daughter are co-trustees. Mom and dad have passed on. And so now I'm working with the two of them. We're sitting at the kitchen table going over how we will put the home on the market. And so do you see a lot of co-trustees?
We do. And actually, it's funny is that most parents, anybody who has more than one child, may think this is the logical thing to do, is just give them equal say. But if those kids didn't get along in life, let alone once you're gone, that may create a conflict. I would suggest people set it up in successive order. Appoint, let's say if they're going to go with the eldest son, great, he's the first successor trustee. If he's unable to act, then the daughter becomes in the second successor trustee. So we have succession without conflict. And that would be very helpful in our world.
Right now I'm working for a trustee and he lives out of town. So they had the oldest son as the successor trustee, and the next in line was a family friend. So the first person said, this is too much, I don't want to do this, and he delegated it to the successor trustee. So that also happens.
It does, and it's actually very wise. Again, think of that, the trust position, right? Who's the trusted individual? Let's say it was the first son, but his siblings were not trustworthy, then the logical thing to do was appoint somebody who was trustworthy. And it sounds like in this case, the son was like, this is overwhelming to me, or I don't feel competent in executing the wishes of the trust. I'm going to pass it on to the next person who we all trusted. And then also in many cases, if children are not trustworthy, then they'll appoint a separate fiduciary to act as a trustee who has no interest in the trust whatsoever. And then therefore they can act without any sort of personal gain to then fulfill the wishes of the settlor or initiator of the trust.
You know, let's say there is a trust, but title is not clear.
Oh, this is what we run into all the time, where a trust was created and it failed to be deeded into the trust. So let's say mom and dad acquired title as husband and wife as joint tenants. They create their trust, but there's no deed from joint tenancy to them as trustees of their trust. So there's a segregation, a separation of title there. And then they pass away. And the children then get the trust and go, great, we need to sell the property. And they are successor trustees, only to find out that the property was never vested in the trust. So this too has to run through a probate process, which is called a Hagstead, which was actually case law, I believe, San Mateo County in 1993. It's a shortcut. It's a streamlined process. It doesn't fail to get the property in trust. Why? Because that was the parents' wishes to get it there. But the thing is that we need to establish that as quickly as possible so we can rectify that and keep it on a marketable track to catch the highest resale value.
Okay, so just to review, sometimes the grandparents or parents will put together a trust thinking everything's covered, but they never put their house in the trust.
And it was interesting. I'll take you back to the 1980s, where transferring property into a trust, which again, a trust in the 1980s was rather rare. The venue to get property into trust was to potentially record the trust in it. So it's fully of record. And that was acceptable at that time. And this is prior to Hagstead. After that time, after 1993, if you failed to put the property into the trust of record, then you'd have to go through the Hagstead portion of it. There was a time in which we could record the trust and attach a legal description to that trust document itself, even after the death of the settlers, to make that happen. But the laws have tightened up considerably since then. So it's taking a lot more legal action between us, being title, real estate, and attorneys, to fix these issues.
And the term that you're referencing, that's just a mechanism. They use case law sometimes as a term,
Correct.
jargon, and that is to bring the family home into the trust using an attorney in the court system so that the family can list the property and sell it.
Correct. And I think part of your question before was the property obviously was intended to be in the trust. If we read the trust thoroughly and they name it either by address or some other fire that we go, wow, this was supposed to be in here. And of course, there's no logic that it would not be, right? Then it was just simply an oversight. So we found ways to correctly rectify that, but we need to know about it as quickly as possible.
We also talked about the provisions in a trust, right? Now, you made a great example at the webinar for Silicon Valley Association of Realtors where our great-grandparents or grandparents lived until their 60s. And now the greatest generation is living into their 80s and 90s and even over 100. And we have capacity issues now with dementia. So that's also addressed in the trust, right?
It is. And what's very interesting about that, and I'll go back and highlight what I said in that webinar, is that, and as you just said, our grandparents died in their 60s of pretty much old age, but many times it didn't include dementia. They were dying of heart attacks and other ailments.
Sure.
Here, the baby boomers have had better food, much better health care, right? So they are outliving their parents by a long stretch. What's interesting about it is that physically they may be okay, but now we're seeing such a rapid inclination in dementia and incapacity. So these trigger points within the trust, usually there's a section in the trust that talks about incapacity, right? How do you determine incapacity and what are the provisions to do that? The one thing that's typically written into, it's almost a boilerplate in a trust, it says that 2 licensed physicians have to date the incapacity or dementia of the settlor to then trigger the successive trustees to act. What I find that becomes our issue, Pat, is that how many people see 2 doctors for the same thing? If I have a foot injury, I go to a podiatrist, not several podiatrists, right? If I have a heart issue, I go to a heart specialist. So getting 2 licensed physicians to write letters to validate the incapacity of the settlor could be difficult. So this is where we start to apply mitigated risk logic and then look at, okay, what are we doing here? Is it safe for us to move forward and only get one doctor's letter, which is the doctor that the settlor had been seeing? And then this is where we talk about what's a logical process versus the letter of the trust. It can become tough at times, but what's our goal? And our goal is to take care of the incapacitated individual, right? Make sure they're taken care of.
They are in that state. They need professional care, which nowadays it used to be $1,000 a month and it was $1,000 a week and even more now if it's memory care.
Right.
Oftentimes they are house rich, cash poor. So we have to sell the property. But first we have to prove to the title and escrow people that their eldest daughter or the successor trustee has the capacity to sell the property, the authority to sell the property.
Correct.
Now, I've been involved, what you mentioned, getting to explain it a little easier here. You need 2 physician letters stating that the older adult has lost capacity to handle their business affairs.
That's correct.
Preferably.
Yes.
You also speak about financial elder abuse. So sometimes there might be children or adult grandchildren that come in here and they want to sell the property and say grandfather has lost capacity, and you look at the documents and grandfather just did the paperwork 2 weeks ago. So if grandfather lost capacity, how is he doing paperwork now?
As you probably remember the story, and I'll iterate it quickly here, where we had a transaction where mom had a trust dated 1988, which right off the bat tells us some things, right? 1988 is pretty rare to have a trust, and that she's of a certain age, because if you're creating a trust in 1988, you're probably of advanced age at that point. We asked for a full copy of the trust and received a recent amendment to that trust, which appointed 2 daughters to act as co-successor trustees.
Oh.
Yep, red flag. And then they immediately put the property up for sale. Now, as the properties in Santa Clara County, it was free and clear and worth well over $2.5 million. So we're talking about a lot of potential cash falling into their hands. what made it even more egregious is that we kept asking for full copies of the trust and they kept denying this. I did eventually reach out to them and say, look, we can't go any further. And I need to speak to mom's doctor to establish her capacity. And they did capitulate on that. We did get a doctor, and the doctor said that he'd been handling mom's dementia issues for well over 5 years. What does that do to a recently executed amendment to a trust? It voids it out. Eventually, they did surrender the full trust to me, and lo and behold, their older brother was appointed as the first successor trustee, of which he knew nothing of the sale of the property at this point. Now, was this fraudulent? Yes. Was there some legal issues involved with this? Yes. And by the way, that amendment was actually drafted by an attorney who notarized mom in her incapacitated state. We even have to look at those issues. But it wasn't so much about taking advantage of mom. This was a sibling issue between the daughters and the son, who were conflicting over who had the right to actually take care of the trust and do things. Well, what we did was we asked pertinent questions. Why are we selling the property? We need the money, back to your point, to move mom into an assisted living facility. We need the cash to take care of her. So as long as that cash, it stays in the trust and the son is handling that and taking care of mom, we can do that. So we involved the son, ratified the contract, moved the daughters out of the way, and they can fight over things after the close of escrow, obviously, whatever that may be. But we're making sure that mom ends up where she needs to be for her care purposes, right?
Let's get into power of attorney. You've seen a lot of good uses of the power of attorney, and you have conversely seen some sneaky uses of a power of attorney.
Correct.
Now, what is, for lay people out there, what is a power of attorney, and can it be specific to just grandfather's house? Or
Yes, absolutely. Now, we deal with that quite a bit. And a power of attorney is a pretty old document. If we put it this way, we can have a specific power of attorney, back to your point, that is specifically for the sale or refinance of a property, right? I appoint you, Pat, as my attorney, in fact, because I'm abroad. I cannot do this thing physically at this moment. And back to the trust issue, I trust you to take care of this thing, but I'm limiting your powers to the real estate alone and to do this one action, either sell it or refi it or what have you. So that's a specific power of attorney that we use in real estate all the time. But the ones that are generally connected to a trust are a durable power of attorney, which is much more long lasting. But this is how it's set up. The trust is for real estate issues, for hard issues, right? Assets are in the trust box, right? The durable power of attorney is for things outside of the trust box. It's for medical care, making medical decisions, separate bank accounts. So dad or mom is slipping into dementia or cannot physically handle these things. This is how I generally see it split up. The son is in control of the trust. The daughter's in control of the durable power of attorney, because generally the elderly live or reside closer to the daughters than the sons. So that's how we see this go. However, how many sons or daughters know that durable power of attorney doesn't entitle them to sell real estate? They feel like they're empowered to do so because they're taking care of their elder parent or grandparent. Exactly. And that they, over a period of time, they feel they're now entitled to do these things. And this is where we run into conflict.
How is a power of attorney done from A to Z?
Well, I've recently seen some very good ones that are so detailed that they're almost drawn like a trust. They have so many provisions in them and in controls, which is fantastic. So we go through those things. I've also seen some horribly drawn powers of attorney that are obviously typed on a Selectric 2 with very little language. So this is why we want to look at these things. And it has to contain specific language in order for them to be able to deal with real estate, which is our issue. And let me give you a quick example. If you set up a trust, they're usually done in tandem, right? Trust is created, durable power of attorney is created. So then they are unified to a certain extent for two different purposes. A specific power of attorney may be executed prior to the need. Let's say back to you and I, right? I appoint you as my attorney in fact because I'm leaving the United States in 30 days. So I'm giving you 90 days to deal with my real estate. It's got a time limit on it. That would be something very specific, right? Or a general power of attorney that doesn't have a termination date on it. However, you and I in our industry have to be very careful that the attorney in fact isn't going over and above their powers. Or here's something that I do run into, Pat, and it's very sad, but an elder parent may give a daughter or son a power of attorney, and they realize that their parent is slipping into incapacity. There is no trust. So they deed the property to themselves, thinking this is the way to circumvent a probate, but you can't use a power of attorney for self-serving purposes. So therefore it's void. And then mom or dad passes away. 5 years later, they go to sell the property. This is when we discover that they've used a power of attorney for self-serving purposes. Now we're looking at a probate. So there's so many moving parts to this. This is why it's so important to correspond with us.
To connect the dots. So we have a will, and we have a trust, we have a power of attorney, and all of this done well will avoid probate court.
Yes, it really helps circumvent that process.
Let's get back to that power of attorney that you thought was done well, and it had provisions in there. So it said, I am granting, the homeowner grants permission. It says, my home at 123 Main Street can be sold by John Smith, my second cousin. Something to that effect?
I'll give you the example directly. There was a wife/mother who was slipping rapidly into incapacity. So they went to an attorney, and the attorney drew up a very specific durable power, allowing the husband to sell the property, right, on behalf of both of them in anticipation of her ultimate incapacity. So they were setting this up. Drilled down within that same power of attorney was a separate power of attorney, which then appointed her daughter to do certain and specific acts on her behalf also. She was the daughter of a former marriage. So there's these provisions, and it was written beautifully, because everything you could almost imagine could go sideways was addressed in this. I was almost laughing because it should have been a trust. It was that detailed. But here comes the hitch. No matter how well this thing was written, and it was beautifully written, it didn't anticipate the death of the husband before the wife. And he died unexpectedly. And power of attorney itself didn't allow the daughter to sell the property. That was the one provision she wasn't allowed to do within this durable power of attorney. She had powers to do virtually everything else. And so the property was now in default. Mom needed to go into the assisted living facility at this point, and they didn't have the cash to go through a conservatorship to have her appointed that way. This is where we fall into that risk mitigation, that risk thought process. So when I jumped in, I did talk to the daughter. She's an only child, so there's nobody else involved. And the best and greatest thing we could have done is to look at the spirit of the document, that it didn't anticipate this, but if it had anticipated this, would she have been empowered to do something? And the answer is logically yes. She's the last person standing who can take care of mom. It's in everybody's best interest to facilitate the sale of the house at the top of the market to get mom into the assisted living facility. Where's the risk? Who comes back at us and cries foul? Even though it wasn't perfect. And keep in mind, insurance, title insurance, like any other insurance, is about acceptable risk or mitigated risk. And so I did accept that power of attorney and allow her to do that. Now, even though it wasn't perfect, it served the greater good.
That's a great story, because oftentimes we do have these situations where mom and dad stayed in their house too long and perhaps let the payments, whether it's a reverse mortgage or forward mortgage, become problematic and go into default. And now we have a situation where, for instance, if mom and dad are in the hospital for 7 months, that might trigger the reverse mortgage to be called.
Right.
All the more reason, that's another issue, is staying in a home too long. And now we have to sell it quickly, and it's not ready for sale. And all the paperwork is a mess. Now, when you make these calls, are the realtors involved? Is it already an escrow, or already have a sale, and then it comes across your desk?
That's a great question, Pat, because why I do these seminars now, and I've started doing this in about 2016, I think to date, I'm well over 5. And the top topic is exactly what we're talking about here, right? Trust issues, probate issues, elder abuse, or potential elder abuse, is because we're just seeing this more and more. We talked about those trends and things like that. So yes, do we get you involved? Yeah, when I go out and do this, I'm trying to be proactive to give you guys an avenue to me, because no one calls an underwriter or a title person with good news. They always call them and say, I have a problem.
There you go.
Unfortunately, they always
Yep.
call us at the 11th hour. It's never up front. So I'll say this is, I apologize to anybody who's been at one of my seminars and heard this over and over. But when you get that preliminary report from the title company, read it, look at that vesting. And if that vested owner is not the person standing in front of you and talking to you, entering into contract, then ask these questions. Who are you? How are you related to the vested owner? And under what authority are you able to act? And then we look at that. Is that a successor trustee? Is it a power of attorney? What's going on in that person's life that is forcing you to do something with the real estate the day before you open it, not the day before we close? So this way we can cure these things.
Good point. And for the lay people out there, title. I have title to my cars. I have a pink slip on a few of them, right? That's title. I have title to the car. You mentioned the preliminary title report. Can you describe what a preliminary title report is for the lay people?
PRT, preliminary title report, is a report based on an opinion of title. It's basically the current snapshot of all the things that affect that property. So if you live at 123 Main Street, we'll put out a report on 123 Main Street and show who the present owner is, what those taxes are, if there's any covenants, conditions, and restrictions or things that you have to worry about, and any loans against the property.
And that's where we get into the problem. A realtor is hired by one member of the family, but they are not on title to the property. And so you have to decide, is it in the best interest of the older adult to close this out and work around it and work backwards with the attorneys and the families?
And this is why I personally reach out and call attorneys, the real estate agents. I'll speak to the sellers or the representatives of the seller in this case, talk to the attorneys. And if they don't have an attorney, I have a list of attorneys that are really good at streamlining this process because they understand what we need and why we need it to take care of mom and or dad.
This is a good tip for everybody listening. Do not put the property on the market until your title and escrow people have thoroughly done a background check on the property and the trust and the sellers.
That's a great point, Pat.
Because there's only one time you can be new on the market, and you don't want to lose that excitement and go into escrow with a buyer and a seller and the real estate firms and then have a problem.
Right.
Let's introduce yourself again for the people that just tuned in, Scott.
Sure. I'm Scott Heisey with Stewart Title Company of California. I am the Northern California Title Operations Manager.
So in terms of financial elder abuse, do you have any tips for the neighbors, friends, family? What can they spot?
Absolutely. It's very interesting is that certainly for us in the real estate world, and if you are a listing agent in dealing with the child of an incapacitated elder who owns the property, are they being genuine? And any of you who have children out there, you can typically pick up on a lie. You get that gut feeling that they're not being truthful or being evasive. And so that's your first red flag. And ask the question, oh, so you're representing your mother and or your father. Where is mom and or dad going? Where's that plan? Because if they're selling the property, they should have a plan in place, not be basically going off the cuff here going, we're not really sure, we're just going to sell the property. That's a bit of a red flag to me. The other part is the condition of the property, the condition of mom or dad. And I'm running into this quite a bit. The statistics say that sons over daughters will commit the fraud, elder abuse, 3-to-1 over daughters.
I thought it was 2-to-1.
It's getting worse, but
It's getting worse.
And daughters are in second place. Strangely enough, those numbers are not going down. They're just going up.
Exactly.
And then so it goes sons, it goes daughters, then it goes grandchildren, and then it goes virtually caregivers after that. Caregivers, anybody doing work on the house type of thing. So we have to be very careful and protect are the greatest generation, just as you said it before. And Pat, you and I are going to be the next generation running into this, right? So I think we need to be more educative and certainly more pragmatic about what we're doing in the community.
That reminds me, because we have to be concerned about our friends, family, our neighbors. I was called out to a friend of my father. He met through business, and she was thinking of selling her condo. I went to visit her, and her adult daughter, who didn't work, was sitting on the couch. And we were at the kitchen table, and every question I asked the older adult, over my left shoulder, the adult daughter would answer, right? And so after a while, I turned to the adult daughter and said, I have an idea. Why don't I ask you the question and your mother can answer? So we have to be aware of, now this is, I'm leading this, and we'll close this out, is if a buyer is interested in a property and a buyer's agent, they should be concerned about a few things too. If it's a home that's been in the family for 40, 50 years, what questions can they ask?
That's a great question. I'm typically dealing with the seller's agent on rectifying those issues that you just brought up. But I think from the buyer side of the fence, that agent should ask, hey, how is this going on? What is the cooperation level? And again, I don't know how much you're able to share depending on which side of the fence you are on. But going back to that example of the two daughters and the son, that there was the conflict and they created the amendment to the trust that empowered them to do something. We need to drill down to, what are you doing? What are your actions about? And in this case, if they're being evasive and dragging it out, and by the way, that scenario, I'd ask a question of the two daughters, they would wait a week before they would answer me. So this transaction dragged out for 6-8 weeks longer than it should have. That was a concern of the buyer and the buyer's agent. What's going on in our transaction? So think of it that way. If you're not getting answers in a timely manner, what's happening on that listing side of the fence that's dragging it out?
Good point, because when I'm representing a buyer and I know there's a trust or a will or a probate or something going on, I'm asking a lot of questions. I'm looking at the preliminary title report and even calling the escrow officer to make sure that we have a proper path to closing escrow.
Correct.
And that we are doing business with the right people. However, when I'm representing sellers, there seems to be no interest and no questions about who has authority to sell this house.
And the buyer side of the fence tends to be more passive. But as we've been talking, you realize how important it is to make sure that this transaction has validity. And I'll give you a reason why we dig so deep, Pat, is because our title policy to your buyer, to your client, covers them for the capacity of the seller, specifically capacity or incapacity of the seller, voidability of contract, and fraud and forgery. And we see some of those wrapped into one.
That's a good point. We have an escrow company. I know in Southern California, it might be an independent mom and pop. They own 5 escrow offices. Explain, what is an escrow office and an escrow officer? What is an escrow officer?
Generally, escrow offices are strategically or geographically located in desirable communities to facilitate the real estate. Los Gatos, for example, is a great place to have a branch, an escrow branch, to facilitate high-end real estate transactions, because it is basically the heart of Silicon Valley to a certain extent, and there's some high-value properties there. So therefore, geographically, title insurance companies would want to be there. So they're the hub. That's where the real estate people will gravitate to, open their orders with. And I'll give you a ratio. Escrow officers, let's say there's 10 escrow officers, you might have 1 title officer is your ratio, 10-1. Think of it that way. So when you said, hey, we would run this through the escrow officer, depending on what type of question it is, and again, if it's a trust or a legal issue, then run it to title. So that's why I'm hoping to get ahead of this. So even if you have a transaction that is at another title company, or you feel funny about, call me so we can talk about it ahead of time before you get knee deep in a transaction that doesn't look or smell right.
Let's follow that. So the escrow office, usually brick and mortar, has a parking lot,
Correct.
Staff. That escrow officer is a neutral third party that facilitates the buying and selling of residential real estate.
That's a great way to put it, Pat.
Okay. And so they take mutual instructions, right? The seller can't come in and bark orders and vice versa.
Correct.
The escrow officer runs everything up the chain to the title officer. And that is a plant down some multi-level building full of attorneys and staff running a background check on the property as well as on the sellers.
I think that's pretty sound. Depending on where you are in the country, it does vary state by state. East Coast does transactions differently than the West Coast. So we have to keep that in mind. If you're listening to this podcast in New York, make sure that you're thinking of it under applicable law, things like that.
And in Northern California and Southern California, we do real estate transactions
Absolutely.
in a different
It's
way, right?
different. Yes. And what's interesting about that is you mentioned this. Southern California has independent escrow companies and title insurance companies who facilitate them marketing wise. So here in Northern California, I would market directly to you because I want your business, Pat. Title companies actually market directly to the escrow companies because the escrow companies have the contacts with the real estate people.
And the reason we want a title insurance company, they will insure clean title for the transaction when it closes.
It's actually, we want to call that marketable title.
Marketable title.
Marketable title, if I insure it in a condition to where you could turn around and sell it, is provided we have identified everything on that property, whether negative or not, it's disclosure process here. So we let the buyer decide, wow, these are items on the preliminary title report, right? Which will then carry over to the policy. And those are negotiated through the escrow process, by the way. But this is about disclosure. This is about showing them everything that affects that property.
Scott, you've been a great guest. Obviously, no wonder I was impressed. You had 500 webinars under your belt by the time I saw you speak. And I understand you've taken up a musical instrument, so good luck on that.
Thank you.
And you've agreed to come back, correct?
I have. I'd love to come back.
Oh, that'd be great. All right, thanks again for watching Compowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We will see you next time.